Bonsoir and bienvenue tout le monde. At this time, I believe I will, yes, so I will call on Mr. Cooper.
Thank you, Madam Chair. I would like to move a motion that I had put on notice, and that is that the committee dedicate 6 hours to study the effectiveness, compliance, and enforceability of the legislated safeguards for medical assistance in dying in Canada under both the C-14 and C-7 regimes. So that is the motion. I believe that it is important that a review of the existing safeguards and instances of possible abuse and coercion be studied by the committee. I would note that pursuant to Bill C-14, there was to be a retrospective review with respect to the provisions in Bill C-14. That review never took place. There have been a number of well-publicized instances of potential abuse, including recently a 51-year-old London, Ontario woman who accessed medical assistance in dying after she could not find adequate housing. Yes, Madam Chair.
Sorry to interrupt you, but in the interest of time, would you be agreeable if I ask the members to adjourn this for today and we take this up next week in a dedicated time for next Monday's meeting?
I would be.
Okay. Is that agreeable to everyone? Thank you. And Mr. Thériault.
Oui, Madame la coprésidente.
Yes, thank you, Madam Chair. I hope that we'll be able to discuss the motion. There was a notice of a motion considering the importance of this committee on MAID with respect to the provisions of the Criminal Code, that for each of the components of the study, and it's not the chronological order of witnesses, but there'll be 2 hours for witnesses on mature minors, 2 hours for advance requests, 2 hours on mental illness, and so many hours for palliative care. Another number of hours for disabled persons. Given that there has already been a certain amount of time to hear from witnesses, this will be taken into account in the calculation of hours for each component. And Madam Chair, I think we should also bear in mind in our motions, we should take into account what was adopted, what was passed in the House when we organize our work plan. Because on June 3rd, I believe we will be dealing with mental health issues.
You are also agreeable for us to adjourn until next Monday to discuss this motion?
Madame la Présidente, ça m'irait très bien.
Madam Chair, that would suit me insofar as if the organization of parliamentary work at the end of this session and with extended hours, that doesn't put us in a situation where the committee would be obliged not to sit as it did last Monday. So I'm saying to everyone, it would be very upsetting if parties were to decide that we shouldn't sit. And there might be such a situation next Monday. So I'm putting that little caveat in. Thank you.
Adjourn until next Monday. Thank you. Okay, once again, bonsoir et bienvenue à la réunion.
So, good evening and welcome to the meeting of the Special Joint Committee on Medical Assistance in Dying. I would like to begin by welcoming members of the committee, witnesses, as well as those watching this meeting on the web.
And I'm the Senate's co-joint chair of this committee, and I'm joined by the Honorable Marc Garneau, the House of Commons joint chair. Aujourd'hui, nous continuons notre examen.
Today we are continuing our examination of the statutory review of the provisions of the Criminal Code relating to medical assistance in dying and their application.
Economy requires that committees adhere to the health protocols, which are in effect until June 23rd, 2022. And as joint chairs, we will enforce these measures, and we thank everyone for your cooperation. I'd like to remind members and witnesses to keep their microphones muted unless recognized by name by the joint chair. A reminder that all comments should be addressed through the joint chairs. And when speaking, please speak slowly and clearly. Interpretation in this video conference will work like in an in-person committee meeting. You have the choice at the bottom of your screen of either floor, English, or French. And with that, I'd like to welcome all of our witnesses for the first panel. As an individual, Louise Bernier, Professor, Faculty of Law, Université de Sherbrooke. Trudeau Lemons, Professor, Scholl Chair, Health Law and Policy, Faculty of Law, University of Toronto. Et de l'Institut de Planification des Soins de Québec, Daniel Califou, lawyer and chair. So each of our witnesses will have 5 minutes, and starting with Ms. Bernier for 5 minutes.
Bonjour, je suis ravie d'être avec vous.
Hello, and I'm delighted to be with you today as you study advance requests for MAID. I deal with diagnosing neurocognitive diseases, and I would like to discuss advance requests. There are 2 ways in which I deal this: the principle of self-determination and qualifiers of consent. So, I will begin with how we support people in making these advance decisions. In my research, I have noted how important it is to not skimp on these supports. They are essential. We feel that we have to think very carefully about how we support people in making these decisions for a request for MAID. So if we are going to open up MAID for others, it's important that this be done in a way that is supported by medical professionals. People who make this decision shouldn't feel that they're disconnected from medical experts. People should be aware of the various scenarios and possibilities. Our protocol in Quebec is something that I've worked on a lot over the past years. And I think that with great care in respecting people's self-determination, what we need is a very simple formula. Before, there was a questionnaire where people would just checked off boxes. But I think if we're going to go forward with advance requests for MAID, we have to do this very carefully. And I imagine that the tool we use will have to be flexible. We'll have to take into account people's priorities. And it also has to allow the possibility for people to ask all the questions they want. And I think that this also could be part of the follow-up in care. I think that in Canada and Quebec, there is this idea of being able to choose ahead of time. But people also need support throughout, and this is something that I have observed from everything I've seen in my work and from everything I've read. We also have to make sure that people can always change their minds. So they need to have a well-informed consent to care. And if they if they make an advance request, this has to be, this can be repeated throughout the process. This has to be an individual choice that is rooted in personal autonomy. But we can't ignore that if a person is incompetent, this decision might have to be made by third parties, who would be healthcare professionals, who are governed by professional obligations by their code of ethics. And it is these people who have to evaluate the situation. And the criteria of suffering which we use, it has to be established that person is in enduring irremediable suffering. So how do we assess this suffering? I don't have an answer, really. Can we allow a person decide what this suffering will be for them, or would somebody have to evaluate their suffering along the way and determine if the person who's no longer competent is suffering enough to merit this? There have to be safeguards for healthcare professionals, for those who might implement the request. And they shouldn't have to deal with these existential questions, because we have to avoid that they also are going to suffer through this process. There's also the impact on the person's family and friends and loved ones. Sometimes these people might decide, but what is their role? Is it already over? Is my time up?
Est-ce que je peux juste terminer sur...
May I just finish? Thank you. My last point, last thing. With medical assistance in dying, this is a societal issue. And care should never be interrupted. It has to be there all throughout.
Give a 30-second warning as well. Next, we have Mr. Trudeau-Lemons for 5 minutes, please.
I thank the committee for the invitation. I was, as Professor of Law and Bioethics, a member of the Council of Canadian Academies expert panel on advanced request for MAID, and have studied MAID and euthanasia law and practice, particularly also the Belgian and Dutch regimes. As others, I come to this with personal experience. I think of my late mother, who lived in Belgium, where euthanasia based on advance request is only possible when a person is no longer conscious. Has a relatively good elderly care. My mother had some reassurances that she would be treated with the care our elderly with dementia deserve and their inherent dignity requires. I think of my Montreal father-in-law, who had a supportive spouse and the means to receive good quality home care. Many Canadians face, however, the prospect of being warehoused in substandard long-term care homes. We already see how lack of resources and quality care leads persons who are not dying to request MAID. It is in this context that AAR for MAID is put forward as a solution to what is referred to as a loss of dignity. Yet, we know that quality care is possible and can preserve dignity. If some recent recommendations are followed, healthcare providers would need to introduce MAID when informing a patient of a devastating diagnosis, say of early Alzheimer's. This ignores, in my view, the dynamics of doctor-patient relations and pressure that can result from professionals suggesting that medicalized death is a solution in a context where a lack of social and good elderly care support are already undermining consent. ARs for MAID further raise insurmountable ethical and human rights concerns, and we should reconsider them, and in my view, not expanding them further. The concerns they raise is reflected in this. Belgium only allows MAID based on advance requests when persons are permanently unconscious, to avoid euthanizing people who still enjoy life and may resist. The Netherlands originally had difficulty with MAID based on advance request, since they considered it impossible to defend it on the basis that persons, quote, suffer unbearably if they could no longer confirm this. It now has permitted it for persons even when they appear to resist. Neither regimes involves explicit contemporary consent, arguably constitutionally required if we take the Supreme Court's emphasis on clear consent in Carta seriously. Allowing ARs for MAID reflects the idea that prior wishes of patients who cannot fully appreciate what future illness will bring has priority over current interests, that this can be done by procedures that give third persons clarity about levels of suffering and patients' real wishes, and that there are no serious implications for family members, healthcare providers, other disabled persons, and society at large. AR for MAID is, in this view, a question of management. The Council of Canadian Academies expert report shows that there is no evidence that procedural solutions can address easily the legal and ethical concerns. Even its discussion of communication tools to reduce uncertainty shows that these solutions are theoretical and speculative. The International Convention on the Rights of Persons with Disabilities explicitly recognizes in its Article 12 the inherent legal capacity of persons with cognitive disabilities. This, we're still conscious, shows what this means. It inevitably involves third-party consent and evaluation of the person's suffering. It usually involves surreptitious medicating patients to suppress resistance and then actively ending life. Contrary to withholding treatment in other healthcare contexts, it involves an active invasion of a person's bodily integrity. Surreptitious medicating and suppressing resistance violate ethical norms and run counter to the duty to enable an expression of current interests of cognitively disabled persons, which the International Convention requires. It moves us into involuntary ending of life. It expresses in law also the view that life with cognitive disability involves loss of dignity. I urge the committee to read a recent article by Belgian and Dutch experts who argue that Belgium should avoid the Dutch approach. Belgium legalized euthanasia in 2002. 20 years later, and informed by the practice in the neighboring country, it still hasn't expanded its AR regime for MAID. Our current AR regime for MAID already goes beyond Belgian law, while our social and healthcare support is below the OECD average. We should listen to experts who tell us, based on the Dutch experience they studied, and these are not people who are against legalized MAID, that ARs for MAID create insurmountable ethical and legal concerns.
Sorry, would you finish up, Mr. Lemons?
Yeah. We should prioritize healthcare and social support that promotes the human rights of all, including those with cognitive disability. I thank you for my time.
Thank you. And finally, we'll have Danielle Chalifou. Oh, you are muted, Madame Chalifou.
Ah, ça va mieux comme ça?
Is that better? Yes. Well, I'd like to thank you, Senators and members of the House of Commons. I have been a member of the Quebec Bar since 1985, and I am president of the Institut de Planification des Soins du Québec, which is particularly concerned with the rights of the elderly and MAID. I have published several articles on these subjects and taken part in many expert committees and government or parliamentary commissions. I have also studied nursing and practiced mostly in long-term facilities and hospices, and this gives me the ability to view these issues in a practical way. Given the limited time available, my comments will focus exclusively on potential legislative changes to the Federal Act regarding advance requests for medical assistance in dying. First of all, I would like to point out that the repeal of the reasonably foreseeable natural death criterion has significantly increased the number of people who can now request MAID. For people with neurocognitive disorders, for example, it is now sufficient that their serious and irremediable health condition be accompanied by an advanced and irreversible decline in capacity and suffering that they consider intolerable and also that they have retained sufficient capacity. I'd also like to point out that the Canadian Association of MAID Evaluators and Providers, and it's an authority in Canada, and they consider that the impending loss of ability related to neurocognitive disorders should be considered an advanced and irreversible decline in ability. So where loss of ability is anticipated in the near future, these individuals may therefore ask for and receive MAID. This option would be supplemented by the option of asking for MAID early, which would give them two options. I'd now like to bring to your attention the fact that some recommend that MAID be allowed only for those individuals who may have been diagnosed with a degenerative neurocognitive disorder prior to their application. If the legislator were to adopt such a restriction, in our opinion, it would be neither legitimate nor legal because it would exclude people who have had sudden and unforeseeable accidents that have led to incapacity, such as strokes or serious head trauma, and who therefore could not have received a prior diagnosis. So we consider in our institute that this is not legitimate because it would go against the opinion. It would go against the opinion of the vast majority of citizens. For example, the recent citizen consultation done by the Quebec government revealed that 91.8% of respondents were in favor of the validity of advance requests for MAID in the case of sudden or unforeseeable accidents resulting in incapacity. It would be illegal because, in our opinion, this restriction contravenes Section 1 of the Canadian Charter and the criteria developed in the Oakes decision, notably for at least two of them. It contravenes the obligation of the legislator to infringe on rights in the most minimal way possible, since appropriate and much less drastic safeguards could be adopted. It violates the rule of proportionality, since the benefits are more of an operational nature, but the detrimental effects would run counter present rights having to do with the self-determination of persons. In conclusion, if the legislator were to adopt this restriction, persons with degenerative cognitive disorders or who had had an unforeseen accident would be deprived of their rights, whereas people in the first category would have two options, while the latter would have none. So people who are in a situation where they weren't able to make an advance request prior to a diagnosis, they would have no option. I just have one little bit left. I think that if this requirement were adopted, this prior diagnosis requirement were adopted by the legislator, it would eventually be struck down, as was the case in Truchon, in the Truchon ruling.
To our co-chair for the first round of questions for MPs and for senators. Mr. Co-chair?
Thank you very much, Senator Martin. Alors, on va commencer la première série de...
So we'll begin the first series of questions with 5 minutes per question, and we'll begin with Dominique Vian. Thank you, Mr. Garneau. Thank you, Chair. Thank you for appearing this evening, witnesses. If you'd like, Ms. Bernier, I would allow you to finish what you wanted to say in your presentation about the necessity to make sure that care is continuous and unbroken. Well, thank you very much. Well, my last point was, if as a society we want to minimize negative effects on the autonomy in a social way. Sometimes we think about the impacts on social perceptions of the illness. So someone who has a prognosis of a degenerative issue sometimes thinks that certain things are expected of him or her, that they're expected to ask for MAID. So we have to make sure that at the same time that we offer care, as Mr. Lemon said, to make sure that those who make a different choice can continue to get care and that there be no break in care, that it be continuous. So I really wanted to mention this because it is so important. There is the societal dimension, but there's also the fact that sometimes people feel that they should make it and they should have the option not to. So are you completely comfortable with requests for medical assistance in dying? Answer: because I wasn't sure. It's not that I'm not comfortable with it, but I think that an advance request is something that we deal with to the best of our knowledge. But I'm not really well placed to say whether it's relevant or not to go ahead or to talk about this. But for me, I think that there have to be safeguards. Because when you talk about consent and individual autonomy, this doesn't happen in a vacuum. We want to be sure that people are receiving the best care and that this continues. Question, I apologize for interrupting, but I don't have much time. So when you talk about supporting these people, I feel that it's very important to foresee this and to provide it. Now, have you ever seen or heard of, do you have knowledge of problems where things went off the tracks, where people weren't completely informed? Or answer: well, I wouldn't say that things went off the rails, but I do see a lot of problems with the present regime. Sometimes people are presumed to be well informed when they sign things, but I wonder if there are sufficient safeguards all the time. Thank you very much. Thank you, Ms. Bernier. And now, Ms. Sharifou, hello and thank you for appearing. Without a diagnosis, you're talking about if there's not a diagnosis. But in Quebec, Ms. Sharifou, there have been advance requests. But they don't go as far as you suggest or as others have suggested. Yes, advance requests in the case of neurodegenerative illnesses. But what about the diagnoses? Answer: well, I share Ms. Bernier's decision on a person being supported and accompanied throughout the process. There are nurses who have noticed how things happen in palliative care facilities. And when there is an advance request that is supposed to be fully informed, they think that there should be modalities so that when somebody wants to make an advance request, they should be able to discuss it, not just fill out a questionnaire, but really discuss it thoroughly, inside out, get all the information they can. Thank you, Ms. Sharifou. We will now go to Mr. Arsenault. Mr. Arsenault, you have 5 minutes. Thank you, Mr. Chair. So, Ms. Sharifou, I would like you to finish what you were saying. Answer. Well, in the National Assembly's commission on MAID, I believe, because we don't know what the bill in Quebec will be, but I think it will have to do about allowing the possibility for people who don't have a prior diagnosis to go ahead. Question? You're saying that people don't have to have a prior diagnosis to make the request? Yes, but I am completely in disagreement with that. Question. How do you make sure that all the people who want MAID can be truly, thoroughly informed? Can you answer that briefly? Answer. Well, briefly, when I appeared before the Quebec Commission, I suggested that they create some sort of group that could do this work, that there be a group that would inform people, just as there is in English-speaking Canada with the professors and providers of MAID. I think that something like this would be necessary. Question. Ms. Bernier. Ms. Bernier, you said earlier that people have to be supported by health professionals. I live in a rural area and we don't always have access to all these specialists and professionals. So to make sure that people in rural areas and in the north have access to the same services, what do you have to say about this? How could we make sure that all people have the same access? Answer. Well, as Ms. Sharifou said, there could be people trained, have the training to deal with this. I think this has to become a standard of care. People will be... Sorry, I have to interrupt you. So you're saying that a nurse practitioner could do this? Answer. Yes, well, there has to be a follow-up, a way of getting the information to these people. And it has to be continuous, not just one time they get the information and that's it. They have to be supported throughout the illness. Question. You're saying this should be a standard nationally? Answer. I think that with the professional groups, yes. I think that this has to be ensured. It's a little out of my bailiwick, but I think that this would be a great opportunity to standardize this care. Question. Last week, we heard from someone who said that advance requests should be reviewed every 5 years. What do you think? Answer. I think it could be perhaps every 5 years or perhaps in shorter periods of time. But I would think at a minimum it should be every 5 years. And things should be constantly reviewed and revised because for people who have experience in this area, people's perceptions rather change after they get their diagnosis. So thank you. Do I have more time, Mr. Chair? You have a minute. Mr. Trudeau-Lemons, can you expand on what you were saying? I didn't quite understand, but for advance requests, you're saying we have to be very cautious. Just how cautious should we be? In other words, would we be so prudent as to hinder these requests? Answer. Well, our experience in the Netherlands and Belgium shows us that sometimes advance requests can lead to problems legally and ethically. Sometimes medication is given to patients to help them but sometimes it's used for euthanasia. I'm sorry to interrupt, sir, but there's not much time. Do you think that someone who has all his wits about him or her could ask for MAID, no matter what else is happening elsewhere? But here in Canada, do you think it would be possible to have the proper safeguards to protect these people? Well, I would say that this would create more problems. Problems for whom? Oh, sorry. Thank you. We'll now go to Mr. Thériault. Mr. Thériault, you have 5 minutes. Thank you, Mr. Chair. Ms. Chalifou and Ms. Bernier. I don't know what I can do in 5 minutes, but in Quebec, we have these advance medical directives. They're not terribly well understood, but when you're in a certain situation, for example, a parent who's in a long-term facility, what kind of care should these people get? Because these advance requests for treatment or for withdrawing treatment, requests surrounding resuscitation, these advance requests for MAID, shouldn't we make this something completely separate, as some witnesses talked about, something which has to do with a process where one is dealing with neurocognitive diseases, degenerative diseases, where there is a whole team and a whole process for the patient until it comes to the point of providing MAID. If someone has an aneurysm or some brain damage, should this not be covered in advance directives? And wouldn't it be a good idea to separate them so that we can go forward cautiously? Who is the question for? Ms. Chalifou first, please. And then Ms. Bernier. Well, I see there are two things in what you've said that are very interesting. First of all, advance requests in Quebec, or directives, are binding. And these have to do with situations which haven't entailed a very long, in-depth reflection. It's a very simple request, whereas MAID, an advance request for MAID, if someone who has a stroke and becomes incapacitated and is in the same situation as someone who has a neurocognitive problem and is in an intolerable suffering, you would have to distinguish this from, you would have to distinguish between the advance request and the advance directives. In my opinion, these are two completely different things. Question. So you think that when there are advance directives that this is very different, but you do agree that we maintain both regimes? Yes. With respect to the support for a patient, Ms. Bernier, you talked about there was a questionnaire, this form that they fill. When there is a diagnosis, they talk about repeating the request and saying that it has a binding nature, that it can be revoked at any time. You talk about identifying objective criteria. You talk about designing a proxy. And this is not someone who decides when. They work with the attending healthcare team. So when that person gets to the threshold of the intolerable, Do you think that this is something that would work? And would it serve to allay your fear about things going off the rails? Answer. Well, with respect to advance medical directives, not many people, I think, use them. I think it's 100,000 in Quebec. And I don't agree with Ms. Chalifou, because I think that these advance directives do cover something like a stroke. Now, with respect to the support for patients, I don't think we can do without this support, constant support. And this is where I plant my flag, because if we don't discuss these things with people, there was something published this year on the importance of these discussions. That people be able to discuss everything, the various scenarios, to discuss the person's values in advance. And you have to understand what their decision is rooted in. It shouldn't be done quickly. There have to be the safeguards and this dialogue. I think that this is very important. Thank you, Mr. Thériault.
You have 5 minutes.
Thank you very much, Mr. Co-Chair. It's quite obvious when you look at the status of healthcare in Canada that many groups just simply do not have access to equitable care. And there are very real concerns from many communities out there about the conversations we're having around this table and the direction that this law could potentially be taking. I guess maybe, Professor Bernier, I'll start with you. Just, on the subject of informed consent, we've noticed that, like, a lot of people, like, when we're talking about the concept of advance requests, they have a fear of, being a burden on their family, but they also have a very fear of, if you look at the state of long-term care in Canada, they have a fear of losing their agency. They look at people who may live with disabilities. They fear being put into that kind of life. I guess in this conversation, we're dealing with very weighty subject matter. I mean, how on earth are we going to fully address this committee's mandate if we're not, it seems like we're putting the cart before the horse. If we're not dealing with those larger societal issues where these bigger, broader topics of there not being equitable care for so many underrepresented groups, what if we're not dealing with that? How are we proceeding on this? Do you have any thoughts on that?
Oui, je vais répondre en français.
Yes, I'm going to answer in French. That was my last point. These things aren't mutually exclusive. If we look at opening up AMAD, I think it would be possible that people could choose that, being conscious of the fact that that's the choice they make. And it could be based in their autonomy. But this always happens in a context which could be cultural, a family context. People are influenced by all kinds of things, and it's very possible that a choice to have access to MAID has to do with a perspective or a perception of the care that is available to one. And it's also possible that whether we like it or not, the people will feel diminished. And I'm not challenging that. But if we go forward with that, we cannot neglect that. It can't be their only option. People are afraid of being abandoned. That's why we have to continue to put all kinds of resources into care for these people, into the quality of care for these populations. I hope this answers your question.
for that. And Professor Lemons, maybe I'll turn to you. I was taking notes as you were speaking, and you were speaking about the problem of procedural tools and their inability to fix these broader ethical issues. Do you want to maybe take some time to expand on that, because that's a very real challenge that we have, I think, and that's the crux of the matter for us as a committee.
Yeah, so I would first of all say the procedural tools that you find in the Council of Canadian Academies report focus on issues of communication, and even at the level of guaranteeing that persons are respected in their future choices when they are no longer the same person or may no longer have the same interest. We do not know, as actually Professor Bernier and also her work with her colleague Professor Regis of the University of Montreal have shown, in the context of advance requests, we know already that this is very hard to actually predict in advance what we will think, what will happen, what kind of interest we will have. So that's one issue that is already not guaranteed by the procedural tools. The procedural tools certainly do not address broader societal concerns, such as the fact that we're crossing the line into allowing third parties to decide whether a person is now suffering intolerably and whether the person's life can be ended. So we're crossing a line which impacts also on our perception of cognitive disabilities more generally. If we do it for people who before becoming cognitively disabled say that they will want to die because they will lose dignity, what do we say to people who have currently cognitive disability and have not made that choice? So we're crossing a line into a practice that undermines a fundamental commitment to allowing persons with cognitive disability to be treated with respect, with dignity, and to be involved in the decision making. So the International Convention on the Rights of Persons with Disabilities emphasizes that. It's not because we lose that we have cognitive decline, that you can say, oh, in the past you made this decision, now we will ignore your current identity, your current interest, and we'll give you a surreptitious medication against your explicit consent, and then end your life. So these issues cannot be solved by procedural means.
Thank you very much. We'll now go to the senators. These are 3-minute rounds, and we'll begin with Senator Kutcher. Senator Kutcher, you have 3 minutes.
Thank you very much, Mr. Chair. I have 2 questions for the witness, Charlefoix. The first one is, do you think that on the basis that concerns have been raised about how advance requests are managed in some countries, that this is a valid reason that advance requests should be prohibited in Canada? Or do you think that Canada can set up its own system of humane and comprehensive safeguards for advance requests, which may differ than that in other countries? And then the second one is, if that's the case, who should develop these safeguards and how should they be implemented? Would a national standards and a certified training program for MAID providers be a useful tool in addressing this issue?
J'espère que vous n'aurez pas d'objection à ce que je vous réponde en français.
I hope you don't mind my answering in French. Your first question, which had to do with experience elsewhere, yes, it's true. There have been things that have happened in a place like Holland, which has had advanced directives for more than 20 years, enough time for them to develop a certain expertise. But I'd like to underscore that in Quebec, there was an expert panel. I sat on it, and we tabled recommendations on a proceeding, how to proceed with how to implement advance directives. And I think that this is a very original a set of recommendations, and which would, I think, respond to how to implement advance requests for MAID. Your second question had to do, I believe, with safeguards. Well, I think it's clear that when one makes advanced medical directives, it has to be contemporaneous. It's something you can evaluate much better than something you would do in the past. And Ms. Bernier, when she talked about how we have to make sure that people are really aware of what they want and aware of all the possibilities, and they do this in an autonomous way. But also, we have the duty of providing them with the best information possible and making sure that their care is the best possible so that their request is free and informed. Now, Senator Meji, you have 3 minutes. Thank you, Chair, and thank you, witnesses. My question is for Ms. Sharifou. I know that the Quebec Institute of Planning Care, in one of their briefs to the Council of Canadian Academies, with respect to advance requests and safeguards, do you think in the 3 minutes I have with you, could you tell me what these maybe what these safeguards are, and get the document to us? I think it was in 2017. I think it might be very helpful for the committee. Thank you. Absolutely, it would be my pleasure to get the document to you. It's been a few years, and things have changed a bit since our in our institute. I'll have to check, because I can't remember all the conditions that were in the document. But with respect to advance requests, all of this had all kinds of safeguards, should have all kinds of safeguards, because when someone is fully supported, then I think only then can you say that consent is free and fully informed. When it comes to the question of providing MAID, all this has to have happened. And this means this means that there has to be a detailed request in which that person, him or herself, makes the request and talks about his or her suffering and why they want MAID. And then that person's will has to be respected. They can work with people who support this person and a family, but they don't make the decision. That person's autonomy has to be respected so that they can decide and make clear their intentions. There were other conditions in our report, but unfortunately I don't have the report before me, but I can certainly get it to you. Do I have a few seconds? You have 15 seconds, Senator. So I will ask Ms. Bernier, since we're talking about safeguards, and I was very happy to hear you talk about the duty to accompany these people and support them. But what do you think about MAID after an advance request? Well, it depends on how the illness has changed. Madame Vien asked me about this. You have to determine in advance, because there are various scenarios, and suffering is something that I can't really take a position because it's our current self which is deciding for a future self. There's all kinds of literature on that. But someone who may seem to not be suffering, Well, for that person, it may be the right time to access MAID. But doctors also have their ethical obligations, so there's a great deal to be dealt with. Thank you.
Senator Wallen, you have 3 minutes.
Thank you very much. I would just like to make a comment, if I could, chairs, that we have heard so many times over the last few sessions of witnesses using pejorative words, making claims about surreptitious medicating and other. I think we need to make sure in advance that our witnesses are reminded that their statement should be supported with evidence and documentation if it is going to be meaningful for us here, and to be qualified to comment on this, because it is our mandate to look at advance requests. My question is for Danielle Chalifou. We talk a lot about safeguards for healthcare professionals, and I think you mentioned that again this evening. I guess my concern is about the safeguards and assurances for the individuals who have sound mind asked through an advance request for MAID when certain conditions were met or when they reached a certain level of decline. How can we actually assure them of those safeguards without something like an advance request being respected and recognized? There just simply isn't any other way.
Exactement. C'est exactement, sénateur.
Exactly, Senator Wallen. In our institute, we say that if someone, when that person becomes, loses their capability, if that person, if they are suffering, sometimes there is no other way of accessing MAID but through an advance request, because if someone becomes incompetent, they can't get MAID, and it would be illegal. And you cannot substitute someone else's consent. Well, I have heard in various conferences I've attended, people do not want, especially when it comes to cognitive disorders. They have seen sometimes in their family, they've seen people who have lost their capability and suffer, and people don't want to go through that. And I understand that this is a very delicate issue. However, we don't always have ideal conditions, but I think it would be very possible to have the safeguards we need that would be acceptable and that would allow people to not suffer intolerably at the end of their lives because they're incapable.
Experience with this, a loved one, a family member who has gone through this and suffered through something like dementia or Alzheimer's, it is reasonably foreseeable what the outcome will be. Therefore, it seems we could make that advanced request.
Je suis tout à fait d'accord avec vous, sénateur.
I completely agree, Senator. Thank you.
Maintenant, passer au sénateur Dalphond.
We'll now go to Senator Dalphond. Thank you, Chair, and thank you to our witnesses for this very this information. Ms. Chalifou, you say that this shouldn't be limited to diagnoses of neurocognitive illnesses, because it could be someone who's had a stroke. But from what you have said, we should have two protocols for advance requests. There could be a case where there's a diagnosis, and there you can make a choice ahead of time, which could be revised in future. But in the other scenario, someone who's had a stroke or something like it, somebody may have made some decision 10 or 20 years ahead of time, and they might want to have revised it. So do you think there should be different regimes, different protocols, depending on the illness? Well, the philosophy behind this is the respect for self-determination. And this continues to apply with both regimes. But what I suggested, in order to avoid that someone, the people who've had cases where they've had parents with strokes, and they want to make sure that certain things don't happen to them, so they have advanced directives. And I think perhaps it was Mr. Arsenault who mentioned this, but at the present time, these things are reviewed every 5 years because there has to be a contemporary, in quotation marks, a contemporary character to the request. People have to say, yes, I still agree with this, or I don't agree with this. And this would be the kind of safeguard that might help. And I'd also like to mention in the care that I have provided for people in palliative care, I often hear from people who've had strokes, who have become incapable, who suffer and are constantly asking for MAID. But Senator Delfaux, I don't know how you can distinguish between these people and those people who've had a diagnosis of a condition that they can't do anything about. But a stroke can happen out of the blue. It's something completely unforeseeable. And these people are deprived of the right to MAID. Yes, I understand that these are different regimes, and they might need different safeguards. Thank you. Thank you, Senator.
Senator Martin. Senator Martin, you have 3 minutes.
Thank you, and thank you to all the witnesses. My question is for Professor Lemons, and I think we have the opportunity to learn from the mistakes of other jurisdictions if there are such lessons to be learned. So based on your experience studying the Benelux countries, are there concerns for abuse or subtle pressure in the context of advance requests? So you're continuing some of the answers that the other members have asked, but and what recommendations do you have, or what caution do you have for us?
Thank you for giving me the opportunity to respond. Contrary to what Senator Wallen questions, she questions basically my integrity. I have studied what's happening in the Netherlands, and what I described is actually the reason why in the Netherlands more physicians now are opposed to medical assistance in dying of persons with dementia than before. And contrary to what Maître Chalifou says, the Netherlands actually did not practice advance requests for MAID in the first years of its legalization. It took many years to start implementing it, and it remains, and it has become more problematic precisely because of the things I described. Most physicians are now reluctant because of the uncertainty and what it involves. And in other words, my message is we're sending false hope to people that they will actually easily have an implementation of an advance request because we do not know how the disease will evolve. 4 out of 16 cases that the Council of Canadian Academies expert panel studied, 4 out of the 16 cases, and so we're not talking about a broad practice that was implemented, involved patients with questionable capacity who received MAID, where the review committees, which do much more detailed work than we have currently in Canada, judged that the criteria, the due care criteria, were not respected. And so they had questions about the practice. So I'm simply stating the facts. And I find it problematic that a senator questions my integrity when I studied this in honesty and with professionalism, and come here as an expert to convey what's happening in the Netherlands and what legal scholars and ethics scholars have recently again discussed. This is the dilemma that we face. We will have to surreptitiously medicate people. We will have to deprive them of the ability to express current wish in order to facilitate the ending of life. And I'm actually very disturbed that a senator makes it difficult for witnesses to talk and to convey their knowledge that they have about practices in other jurisdictions. I find it very inappropriate. We're here in the parliamentary democracy. You invite experts to come and talk about what they know, and you treat them like this. I think it's inappropriate, and I apologize, Mr. Chair and Madam Chair, to say this here, but I'm very disturbed by this.
Thank you very much. Unfortunately, this ends our first panel. Alors, il ne me reste qu'à vous remercier.
So I would thank you, Ms. Chalifou, Professor Lemons, and Ms. Bernier. Thank you for having appeared this evening, especially with a week delay. Thank you for your testimony on a subject that is so serious, so fraught with consequence for our people. Your input is very appreciated, and I'm sure it will help inform our report, which should come out in the fall. Thank you again for appearing today.
Suspend the meeting temporarily as we prepare for the second panel. Thank you, everyone.
as an individual, Jocelyn Downey, University Research Professor, Faculties of Law and Medicine, Dalhousie University; Dr. Catherine Ferrier, Physician, Division of Geriatric Medicine, McGill University Health Center; and Dr. Susan McDonald, Associate Professor of Medicine and Family Medicine, Memorial University of Newfoundland. So thank you all for joining us this evening. We'll begin with opening remarks by Ms. Downey, followed by Dr. Ferrier and Dr. McDonald. So Ms. Downey, you have 5 minutes. The floor is yours.
Thank you, and good evening. Thank you for the invitation to appear before you. My name, as you heard, is Jocelyn Downey, and I'm a university research professor in the faculties of Law and Medicine at Dalhousie University. I have provided written submissions, including relevant references to the clerk, and in my 5 minutes, I will introduce some key points for your consideration. I believe that there are 3 main questions before you on the issue of advance requests for MAID. 1, whether to allow them, and if so, 2, when to allow them, and how to implement them. First, a word about terminology. Throughout my remarks, I will use the phrase advance requests instead of advance directives. This is critical to avoid confusion between the relatively new federal regime for MAID governed by the Criminal Code and the already well-established provincial territorial regimes for other healthcare. With that, on to the questions at hand. Let's start with whether to allow advance requests for MAID. I encourage you to recommend that Parliament do so for a host of reasons. First, all of the many expert committees and panels that have studied the issue and had a mandate to make recommendations have recommended this. Second, public opinion strongly and consistently supports it. Third, the courts and provinces and territories have said that individuals should, while capable, be able to make refusals of treatment that are binding after they lose decision-making capacity. What this means is that I can have an advance directive that says when I reach stage 7 of Alzheimer's or have lost capacity due to Huntington's disease, I refuse all food and liquids. The clinicians must respect my directive. So I will die of dehydration and starvation. Or if you change the law, I could have MAID. To deny MAID is both illogical and cruel. Fourth, Parliament has already made the decision to allow some advance requests for MAID. Final consent waiver and advance consent, introduced through Bill C7, are 2 forms of advance request. Fifth, some persons with dementia already have access to MAID. They are carefully tracked by a provider, closely monitoring their diminishing capacity, state of decline and capability, and suffering. After they have met the eligibility criteria for MAID, but before they have lost capacity, they can either access MAID through what is known as the 10 minutes to midnight protocol or sign a final consent waiver. But they must have a provider willing and able to do this, and they may live for years in fear of not getting the timing quite right and not getting MAID. Sixth, the concerns that you will hear during your process either A, aren't conceptually coherent, B, apply to that which we already allow, and or C, can be addressed through procedural safeguards. I cannot, in the time allotted, do justice to the complexities of, for example, personal identity, critical interests, precedent autonomy, the paradox of disability. But I can commend to you the analysis in the 2019 report from the Quebec expert panel on the issue of incapacity and medical assistance in dying. Finally, there has been enough time to consider this legislative reform. From the Provincial Territorial Expert Advisory Group in 2015, to the Special Joint Committee of the House and Senate in 2016, to the 2019 Quebec Expert Panel, and the 2021 Quebec Special Commission. This has not been rushed, far from it. Now let's turn quickly to when. I encourage you to recommend that advance requests should be permitted after diagnosis with a serious and incurable condition. Finally, let's turn quickly to how. I encourage you to reflect the philosophical justifications for advance requests, for access and for protective measures, the values reflected in our existing laws, and the realities of clinical practice in your recommendations. To that end, I encourage you to recommend that the law first require that a valid advance request document spells out A, what the person considers will be intolerable suffering, and B, objectively accessible conditions for triggering the advance request. Second, establish what to do if the now incompetent person appears to have changed their mind or does not appear to be suffering.
30 seconds.
Specifically, follow what the person said should happen if they appear to have changed their mind or do not appear to be suffering, and require, as part of the informed consent process, the disclosure that this may happen. Third, require that the request be renewed on a regular basis so long as the person remains competent. With that, my time is up, and I thank you for your attention, and I welcome your comments and questions on anything that I have said or any other matters of interest to you.
Thank you, Dr. Downey. And next we'll have Dr. Catherine Ferrier.
Thank you very much, Madam Chair and Mr. Chair. I'm happy to be here. I am a physician in the Division of Geriatric Medicine at McGill University Health Center since 1984. My practice is focused on patients with dementia. I'm an expert in decision-making capacity assessment. I see victims of elder abuse. I teach on these topics and testify frequently in court for my patients. I have cared for and accompanied thousands of people with dementia and their families. My perspective is very different from those who view my patients from an academic or political point of view. I have learned how well people adapt to the changes in their life wrought by cognitive decline. There are many challenges, not least of which are the ageism, ableism, and neglect they face in the healthcare system. Despite this, most people do well when measures are put into place to support them and their families. In 38 years, none of my patients or their relatives have ever requested MAID because of a dementia diagnosis. I've noticed in this debate the assumption that written advance directives are a proven tool that enables autonomy and provides adequate free and informed consent to medical interventions. This is false. For consent to be valid, it must be voluntary. The patient must have the capacity to consent and must be informed. Consent is informed when the patient has received and understands detailed information on the diagnosis, including any uncertainty, their proposed investigations or treatments, their chances of success, available alternatives and their risks, and the potential consequences of leaving the condition untreated. Advanced consent can never be fully informed. The 2018 CCA expert panel on MAID by advance requests cited knowledge gaps and a lack of evidence regarding its safety. They reviewed the literature on advanced care planning, a field that's developed to improve medical decision-making toward the end of life. ACP is not limited to advanced directives. In fact, its scope is becoming broader over time as the limitations of such directives, also called living wills, become evident. Articles published by experts include Why I Don't Have a Living Will in 1991 and Enough, the Failure of the Living Will in 2004. Definitions of ACP refer to a reflection and communication process to ensure goal-concordant care near the end of life for people lacking decisional capacity. Components include discussion of broad life and healthcare goals and naming a substitute decision maker. Of the research reviewed by the CCA panel, very little studied written directives alone. The report mentions no evidence that written directives affected any meaningful outcomes, and in one Canadian study, the documented preferences did not match the expressed wishes of the patient 70% of the time. A 2020 review of 69 studies found no effect of advanced care planning on goal concordant care or quality of life. These results make sense given the evidence that people predict poorly their quality of life in hypothetical situations. This has been attributed to known cognitive biases such as projection bias, projecting current preferences on future situations, focalism, focusing on what gets worse, not what remains positive, and immune neglect, underestimating one's adaptive capacity. We often see a change in preferences for care as a person adapts to advancing illness. This is true even in dementia and is why we respect the current wishes of incapable patients as long as they're not harmful to the patient. More and more end-of-life experts express serious doubts about the utility of written advance directives. Recent articles include Advanced Directives Care Planning, Clear, Simple, and Wrong in 2020, What's Wrong with Advanced Care Planning in 2021, and Should We Still Believe in Advanced Care Planning in 2022. Morrison et al., the authors of one of those articles, state, treatment choices near the end of life are not simple, consistent, logical, linear, or predictable, but are complex, uncertain, emotionally laden, and fluid. Patients' preferences are rarely static and are influenced by age, physical and cognitive function, culture, family preferences, clinician advice, financial resources, and perceived caregiver burden. For these reasons, there's been a shift in practice from promoting written documents to a dynamic process of dialogue. This is the standard of care for end-of-life decision-making. It is absurd and alarming that written directives, having failed for ordinary treatment decisions, are now being contemplated for MAID. To cause the death of a person with dementia who's not asking for it on the basis of advanced consent that is necessarily uninformed is contrary to autonomy and beneficence and has nothing in common with treatment withdrawal decisions. There's a broad consensus in ethics and medicine that to directly cause death is distinct from allowing death to occur through the natural progression of an illness. Advanced directives for MAID would lead to elder abuse through manipulation and forgery of directives. I've seen it with powers of attorney where the consequences are not nearly as grave.
30 seconds.
If MAID by advance request became legal and binding, Canada would be the only place in the world where a state agency is obliged by law to kill an innocent and defenseless person. Thank you.
Thank you, Dr. Ferrier. And our final panelist, Dr. Susan McDonald. You have 5 minutes.
Bonsoir et salutations de
Good evening from Newfoundland.
to palliative care for 30 years and have had the privilege of caring for thousands of patients and families. I provide secondary assessments for MAID and have had a close relative utilize MAID. So my words today will reflect on my personal thoughts on the subject rather than supporting any organization. I feel that MAID is an end-of-life option that can be part of palliative care but is not exclusive to it. Many of us who practice palliative care are involved to some degree in the provision of MAID, whether it is to fully inform our patients of all their options, including MAID, to discuss in depth this option with our patients, to be the second assessor or the primary provider. There will always be a divide between clinicians on the subject, but regardless of a clinician's personal feelings, the patient has a right to know about this procedure and what the criteria are and how to obtain it. From a practical point of view, here are my thoughts about MAID and advanced directives. My first concern is about palliative care. Not everyone has access to palliative care, and provincial and local issues dictate whether there's anyone with skills in this field of medicine and how available they are. Virtual care has limitations and cannot fully compensate for this lack. Some patients could benefit from our service but are limited access because their physician refuses to refer or because their local program has limitations regarding who can have services and for how long, or because there may not be anyone available to provide in-home care. There may be no paramedics trained to provide palliative care at home. In my jurisdiction, having this service very significantly reduced the number of admissions to institutions. Good symptom management and support at end of life, whether it be in the last years, months, days, or hours, is a human right, and we're failing the Canadian people when our postal code determines your access. My other concern is that MAID is not routinely offered as an option. Ideally, all the choices for patients should be outlined early to give patients ample time to consider what options work for them and which do not. Not informing a patient that MAID is an option is both not fair to the patient and doesn't follow the guidelines for informed consent. For example, would we consider that a patient who is newly diagnosed with cancer be offered surgery, radiation, and symptom management only if chemotherapy was possible? Would we say to ourselves we don't offer chemotherapy unless the patient specifically asks about it? Of course not. Yet this happens over and over with MAID because there is the perspective of some clinicians that they cannot raise the topic, and to mention it is to encourage or solicit a patient. Patients require time to consider their options. What's in keeping with my personal philosophy? What can I afford? What can I obtain? What does my culture or religion or personal values tell me is right? We know that some populations in this country have less access for MAID than others. We must continue to be mindful about this and work hard to ensure that every Canadian has the opportunity to avail of all of the end-of-life choices that suit them. Patients should be able to obtain MAID wherever they live. However, there's still institutions and organizations that deny MAID on their premises, and my own relative couldn't go to her local hospice because she wouldn't be allowed to have MAID there. MAID providers should have adequate training and support, and this should be standardized across the country. Many providers find they need adequate breaks or supports when involved in this type of care, and we need to ensure there are enough clinicians who thoroughly understand what they're doing and how to do it. And there has to be continued to be clear oversight, data collection, and frequent evaluation. People should be able to determine whether they want MAID at a future date, should they become incapacitated. Many of my patients have told me over the years that the one thing they fear the most, beyond pain, beyond shortness of breath, beyond anything else, is the loss of ability to make their own decisions. This creates tremendous human suffering. MAID has been a positive addition to the list of possible ways for me to care for my patients. It's a gift for those who want the option of control, that there's always an escape route if things got too bad. But sadly, many patients are very unaware this option exists, and they can't create a tool so that they ensure that they get it at the time when they want it. The MAID deaths I've witnessed have been the easiest and most peaceful of my career. While most of my patients do not end up utilizing this option, increasingly more do.
30 seconds.
As a palliative care physician, it is my privilege to help all my patients get the death they want. Thank you very much.
Thank you, Dr. McDonald. Now we'll go into questions from our members. The first questioner for 5 minutes will be Mr. Cooper.
I believe actually it's Mr. Barrett.
Oh, Mr. Barrett. Okay, I'm sorry, Mr. Barrett.
Thanks very much, Madam Co-Chair, and thank you to the witnesses for appearing today. Dr. Ferrier, did I pronounce your name correctly, ma'am?
Yes, that's perfect. It's Ferrier. It's not Ferrier.
Okay, Dr. Ferrier, I was wondering if you could tell me about how we can make advance requests safe. So by ensuring the person signing the request is fully conscious of what they're signing and the authority that it gives.
Yes, thank you for that question, and I'm happy to address it to the chairs. So I heard a lot in the last hour about how to prepare people to sign advance requests. But in my view, and in the view of the medical literature on advanced care planning, that is still not adequate consent because you're lacking many, many elements of what you would need to know to consent to any kind of procedure. And in my experience, people sign all kinds of things without knowing exactly what they're signing. I've seen many, what we call in Quebec, mandat de protection, protection mandates, which are supposed to be just to name an alternative decision maker. For some reason, have started having end-of-life wishes inserted in them, which are so vague and general that they basically authorize any random doctor who meets you in the emergency room to decide that a treatment is superfluous given your condition. And it's very dangerous. And the patients, I say, well, what did you mean by this? And they say, it means I don't want to be a vegetable. And essentially, it was not their wishes. It was a text that was given to them by somebody they trusted, and they signed it. I would expect the same thing to happen, regardless of all of the safeguards that I've heard about in the last hour or so. Because right now, with the MAID regime in Canada, there are all kinds of people dying by MAID that are horrifying the whole country. And I can tell you even more stories from my own experience and that of people around me, that safeguards don't work and that documents can be abused. I've seen documents abused in my practice in geriatrics all the time. I could tell you many, many stories, but I don't think I have more time to tell them right now.
Okay, thank you. Thanks, Doctor. So in your answer or in your opening comments, you talked about advance requests for MAID being used in elder abuse cases. Can you elaborate on that for me?
Yes, I'd be happy to elaborate. So obviously that has not happened because advance requests are not legal in our country, but there are documents that delegate decision-making authority to another person. And I've frequently been to court with families squabbling over who has authority over this patient. It's often about money. It's often about how much of the inheritance will be used up paying for the care of this older person. So I can, it's not 100%, but I think that will happen. The same thing with requests for MAID. It is expensive to care for people. Family members and people around my patients are not always, let's say, benevolent, and are not always acting in the interest of the patient. I've seen forged mandates. I've seen mandates signed without understanding what people were doing. There's a lot of dysfunctional social groups in this world, including families, and I can see that this would just explode with the number of people getting dementia now. It worries me a lot. My patients are very vulnerable, and you can talk as much as you want about autonomy, but even without dementia, they are often not as autonomous as theoreticians think they should be.
Right, and so I appreciate the clarification in your response that advance requests are not the law of the land here, but they are elsewhere, and so advance requests are legal in other countries. Can you relate that to your previous answer?
Are you asking specifically about elder abuse?
Well, yes. What the effect of building on your previous answer of advance requests has been in other countries?
About 40 seconds.
Okay, so I think I couldn't say better than what Professor Lemon said in the last hour about how in the Netherlands, for example, the popularity of advance requests is going down, not up, because of all of the hazards and problems and lacks of safety that are being demonstrated in that country. And I think that that's very valid evidence for what we decide in Canada.
Okay, I think I'm out of time. Thank you very much, Dr. Ferrier, and thank you, Madam Co-Chair.
Thank you. And next we'll have Mr. Ananda Sangari for 5 minutes.
Thank you, Madam Co-Chair, and I'd like to thank the panel. I'm going to focus my questions to Dr. Downey. I know you indicated in your testimony that advance requests should be made at diagnosis or after diagnosis. Can you indicate if there are any situations where that can be made before diagnosis?
I would say that from a public policy perspective, I'm not advocating for that right now. I wouldn't be arguing it against it, and I wouldn't want to be trying to defend not having a broader approach in court. You heard the arguments around that. But I do think that they are different. And I think one of the principal areas they're different is, for instance, in terms of the amount of information that you may have available to you in order to make a decision. Once you've got the diagnosis with a serious and incurable condition, I think you absolutely can make a free and informed decision about an advance request for MAID. I think we need to think differently about it if it comes earlier.
So can you maybe elaborate on the mechanics of what an advance request would look like at the end of life? So at a point where somebody loses their ability, their capacity to make a decision.
So when it's being triggered and used? Okay,
yes.
So yeah, because what's really important is that I think we need to think of these differently in terms of the procedural safeguards and the documents, what they would look like, what the processes would be. There are indeed failings in the advance directive regimes. I'm not looking to graft this onto those. I think that what you would do is you would have the person write a document in collaboration with a clinician. It's a written arrangement. It's an agreement between people. And it would set out what the person considers to be intolerable suffering, and then objective criteria for determining whether those are met. So, for example, my intolerable suffering might be about a loss of personal identity, personal integrity, dignity, my own conception of dignity. What I couldn't do is just say, when I no longer have personal integrity, how can somebody else assess that? But what they can assess is, for instance, if I say, I can no longer name my spouse or children any day at all for 2 weeks straight. I could say that. Or I could say, when I am in stage 7 dementia, that is an objectively accessible condition that I tie to my personal determination of what constitutes intolerable suffering. So what would happen is somebody says, this person has lost decision-making capacity. There is an advance request. Here are the objectively accessible conditions for the provision. Have they been met? The clinician would be able to assess that.
So, Dr. Downey, at that point, is it a clinical decision, or is it a decision of a substitute decision maker, or is it a combination of both?
It is, I think, never a decision of a substitute decision maker. There is no room for substitute decision making in this context. It is the individual who is saying what is to be done to them at a point at which they have lost decision making capacity, and the clinician assesses the objectively accessible conditions, because you've sorted that out in writing down your written request. You've figured out what will work, what is something that clinicians can actually assess, and they determine whether those have been met or not. So no substitute decision making here at all.
Thank you, Dr. Downey. I'll pass my time to MP Maloney.
Okay, there's 1.5 minutes.
Thank you. My question is for Dr. Ferrier. Doctor, you said advanced consent can never be fully informed. Informed consent is a legal concept designed to protect a patient, as I understand it. Arguably, nobody can ever be fully informed when they give consent in medical situations, but they do their best, and this is no different. So my question to you, doctor, is if I am in a situation where I have a terminal illness that I know cannot be cured, my fear is not dying, my fear is living in misery. If one of the factors that I consider in making my decision to provide consent in advance is that I will not be able to communicate when the time comes, is that not properly informed consent? Because I'm taking that into consideration. I'm fully aware of the circumstances and what they might be then.
30 seconds.
So you're informed about theoretically what the experience of dementia might be to you?
No,
Sorry,
doctor, I've got terminal cancer. I know I'm going to die. I know I might be in a situation where I might not have the cognitive capacity to change my mind. But I've made the decision that I won't have the ability to change my mind, and I know I don't want to live in misery. Is that not informed consent?
Well, that is already legal for one thing. It's not what we're talking about here, I don't think.
No, you're talking about advanced directive versus an advanced instruction for MAID.
Yes.
But the waiver of consent is already in the law.
No, I'm talking about provision of MAID, not withdrawal of medical services.
Yes, I understand. That's what I'm talking about too.
Thank you. Next, we'll have Monsieur Thériault for 5 minutes.
Merci, Madame la coprésidente. Je vais mettre...
Thank you, Madam Chair. My question is for Professor Downey. When it comes to an advance request for MAID in the case of a degenerative neurocognitive disorder, there comes a time when a person who is aware of him or herself, relationships, their culture, and are dealing with existential sufferance. And this versus a state of biological life, which happens in the final stages of Alzheimer's, when people enter a vegetative state. Do people have to wait to that point for it to be considered morally acceptable to give people access to MAID, to perform MAID? Or should there be criteria defined by the patient, him or herself, at an earlier stage?
I believe absolutely that it is for the individual to determine what constitutes a life of enduring and intolerable and irremediable suffering for them, and that it's very clear that that can be physical suffering or psychological suffering or existential suffering, and it's for the person to decide what that will be and then to very carefully lay that out so that when they are no longer competent and capable of decision making for themselves, that written request will be able to speak for them. And it need not be at the end stage. They may consider a life of intolerable suffering to come much sooner than end stage dementia, for instance, and they're allowed to make that decision.
Effectivement, c'est-à-dire que lorsqu'on vit...
Yes, indeed. And when one has dementia, there does come a terminal stage, but people can survive a long time after that stage. They may not even die of that particular condition. They'll die of some other condition, perhaps linked with it. So could you see two regimes where there are advance requests versus what we have in Quebec, advance medical directives for two different kinds of medical conditions? And I'd like to add this because we don't have much time. Would you consider that a diagnosis is necessary for this?
So the first thing I would say is please do not blend the two regimes. So think that if it's dementia, you go through advance request, and if it's something else, you go prior to diagnosis, you go through the mandat or what the advance directives in any other province. Do not blur them. This is a federal issue. It is dealt with under the criminal code. MAID can only be dealt with that way, I believe. So you could have two regimes under the federal criminal code for advance request. So one would be for when you have had a diagnosis with a serious and incurable condition, and the other could be prior to diagnosis. I think they would have different procedural safeguards because you have different amounts of information available to you. They might be at different times. They're much more likely to be at different times if it's pre-diagnosis, that kind of thing. So I could see two federal regimes, but I don't see MAID ever being dealt with under a provincial advance directives regime.
Est-ce que vous préconisez qu'il...
Do you think that there will be it will be better to do this before diagnosis, or do you think that there absolutely has to be a diagnosis?
I think the case is made most strongly where you have a diagnosis for serious and incurable condition, because you can respond to a lot of the concerns that people have about advance requests, such as you don't know what condition you're even going to have. So how can you possibly project yourself out into the future and know that that constitutes intolerable suffering? So you do have that piece of it that you can predict better, and that helps people feel more comfortable, and it actually undermines some of the arguments against advance requests. One thing I'd add, just in relation to something you've been saying, is
Dr. Downey.
Yeah, people who are before diagnosis, and so people have been talking about stroke and so on. One of the things I think we also need to do is inform people about alternatives to MAID in those circumstances. Those include palliative sedation and voluntary stopping eating and drinking. Quebec has done a much better job about palliative sedation than the rest of Canada, but we should be talking about the entire spectrum of end-of-life care.
Okay, thank you. Merci. Next, we have Mr. McGregor for 5 minutes.
Thank you very much, Madam Co-Chair. Maybe Dr. Downey, I'll continue with you. This very much is an issue of personal agency and people making very personal and tough choices. I guess, like for me, when you speak to a lot of people, you have to acknowledge that out there's a lot of stigma surrounding dementia, right? I mean, people are very afraid of getting that diagnosis. They're very real concerns with long-term care. We've seen the worst of the worst through the last 2 years of just how bad it can get. So there is a very real fear about the level of care that exists. And I guess, one thing I'm personally struggling with is, like, if we do permit a regime where advance requests for MAID are permitted, like, how do you think that people's fear about the lack of caregiving options that exist out there for people with dementia, like, how do you think that's going to influence their decision in making that advance request? And like, how do we appropriately deal with that very real issue as a committee?
Yep, very real. So several ways. The first is to point out that the stigmatization, in some senses, goes in both directions, in that if you don't let people have advance requests and you say, you're in a sense saying that people with dementia can't be trusted to make decisions for themselves in the future because they're too vulnerable to these external pressures and so on. And I think that itself is stigmatizing of persons with dementia. The second point is, it is the person's decision. It's not society saying your life as a person with dementia is not worth living. It is only for the person. I would never say somebody else who has dementia, their life is not worth living. It is for the person to say whether it's intolerable suffering. So it doesn't carry a stigmatization because it's internal. The thing about supports and services, this is your opportunity to be bold. And it is to be bold about the parallel tracks. Your committee sitting in the House and the Senate, you have federal levers to improve the supports and services for people with disabilities and with mental illnesses. And my whole argument all along has been parallel tracks. For the individual, you have access to MAID while you're capable or through an advance request. At the very same time, we put a huge push on, we shine a very bright light, and we demand accountability for improving the supports and services that are so desperately needed. They're not mutually incompatible, and in fact, by having a conversation about MAID, we now have an opportunity for people to listen to a conversation about supporting persons with disabilities and mental illnesses in Canada. So that's where I hope this committee is bold, is to figure out ways. Do you use the federal purse? Do you use the convening powers? You have all kinds of tools. Use those to fix the problems that are coming to light and people are finally paying attention to. But don't constrain access to MAID, because you should never make individuals hostage to fixing systemic problems.
Mm-hmm. And like anything, maybe to expand on that, not just people's fear about getting a dementia diagnosis, but also, many marginalized communities in Canada, the disability community, like groups that have experienced systemic lack of equitable access to healthcare through their entire lives. And anything further you want to add just on the very real fears those groups are presenting to us as well?
I think they need to hear the evidence about the impact on vulnerable populations, and it is not what is being presented. I would plead for you to talk to the primary authors on the empirical research that's been done in the Netherlands, in Belgium, and also in Canada, none of which demonstrates that there is this vulnerability. If anything, there's a vulnerability to not getting access to MAID amongst those populations. So that would be the first thing. The second thing I'd say is denying access is not going to mean people get access to, denying access to MAID is not going to mean people get access to these supports and services. All they're left with is the life that they have just described to you as one of intolerable suffering. They're left in that life, because it just doesn't work that way at the individual level, that they're suddenly going to be offered all of these other options. So I say back to that is, we hear you about your concerns, and circling back to what I said before, you are right to be dissatisfied with how Canada and provinces have supported you, but don't be concerned that this is going to put you at risk. Allowing access to MAID through advance requests or the sunset clause, that won't cause that.
Okay, thank you, Dr. Downey. I'll now turn this over to the co-chair for questions from senators.
Thank you, Senator Martin. We'll go to the senators. These are 3-minute rounds, and we'll begin with Senator Kutcher. Senator Kutcher.
Thank you very much, Mr. Chair. Before I start my 3 minutes, I would just ask that Dr. Ferrier provide us with the evidence to support the statement about elder abuse through forgery of advance directives. So we'd like to see the research studies for that, please, Mr. Chair. The question is for Professor Downey. We've heard opinions that it is a clinician or a third party who should define what an irremediable medical condition is for a patient. Others have opined that it is the patient who determines what an irremediable medical condition is for them. I'd like your thoughts on that. And then the second question is, we've heard opinion that procedures or safeguards cannot provide society with comfort that advance requests can be properly discharged. And what is your thinking on that issue?
Okay, so on irremediable, I am unmuted, okay. Irremediability, I think it's two things are going on. One is for the patient and one is for the clinician. So the patient decides what treatments, if any, they're willing to try. And then the clinician can say, that will, or here's what I understand about whether that will or will not work. That's a clinical choice, but whether the person wants to take the treatment is a moral, personal choice for the individual. So we have to think incurability similarly. We have to think about them as having different roles and ground them in what expertise each has. The patient has expertise in what constitutes suffering to them and what their values are and what gives them meaning. And the clinician has expertise in what does this treatment do for this condition, what's the trajectory, and so on. On safeguards, one thing I would say is we don't have evidence, I mean, that there is any risk of all of it, because in part, some of what you've heard of as harms and abuses, I have not seen that evidence, and I don't believe it's there. It's how people are reading things. And so I think that the safeguards, we absolutely can. And the other thing I'd say is we're already doing it. So if we think we don't have safeguards, adequate safeguards, then we need to be changing a whole bunch of other things that we're doing, including advanced directives, substitute decision-making in ICUs, final consent waivers. All of that is premised on us having safeguards that are adequate. And those same and enhanced safeguards will do the job.
So have you finished, Senator Kutcher?
Yes, I have. Thank you very much.
Thank you very much. We'll then go to la sénatrice Mégy. Vous avez 3 minutes.
Senator Mégy, 3 minutes. Thank you, Chair. And thank you, witnesses. My question is for Dr. Downey. An advance request or advance directives, how are these two things different provincially? And if an advance request is allowed after a diagnosis or without a diagnosis, how are the regulatory contexts different?
So advanced directives happen at a provincial territorial level. They are about largely withholding and withdrawing treatments. And so I get to make a decision now about what treatment decisions I want made, how I want them made in the future should I lose decision-making capacity. Important to note there are two kinds, instruction and proxy. So instruction is I say, these are the decisions I want. It's written down, I tell you. Proxy is I say, I want my sister to make decisions on my behalf. I say nobody who's advocating for advance requests for MAID is suggesting we would have proxy directives. We would only have an instruction. So that's the provincial context. The federal context, the advance request context is federal. It's dealt with through the criminal code. It is only for MAID. It is only a written request developed and signed in the context of a clinician-patient relationship, probably multiple clinicians, over time as the person is fully informed, as all of the eligibility criteria for MAID are checked, such as voluntariness and the information and so on. So they cover different healthcare interventions and they have different rules. They are regulated in different ways. Because the federal one would be regulated by the federal government, and the provincial ones are done through provincial and colleges and so on.
Merci. J'ai du temps pour une petite question pour...
Thank you. I also have a question for Dr. McDonald. 45 seconds. Dr. McDonald, can you tell me briefly, what about the palliative approach within the context of an end-of-life patient? I know you work with these people.
I do. And part of the end-of-life process is ensuring that patients are aware of what their options are, what they can choose from. And so understanding what their disease is, what they can expect from their disease, how that disease is going to progress, what kind of symptoms they're likely to experience, and then from the clinician's point of view, what I can offer to help with each of those symptoms. And that's where I was saying earlier, I really think that patients often don't know about medical aid in dying as an option. It's still, I mean, we know a lot about it because we're very invested in it and we're all here to talk about it. But the average patient, you'd be surprised, doesn't know that that's even an option. And a lot of clinicians do not raise that. They wait until the patient has said the secret word about what about this euthanasia thing, and then they'll talk about it. That's not informed consent when you don't have all your information so you can pick and choose what is right for you. And people need time to think about all these options. So
Thank you. Thank you, Dr. McDonald. Senator Wallen, you have 3 minutes.
Thank you very much. I have a question for Dr. Downey, but first I'm going to ask her to clarify something that I read in the record of our meetings. I think it was a question to a witness, and I'm just going to quote, and here it is. The Supreme Court of Canada stated unequivocally 3 times in Carter that medical assistance in dying may only be performed when a patient clearly consents. In the face of the pronouncement of the Supreme Court, do you believe that an advance directive can be a true expression of free and informed consent consistent with Carter? That was the quote. Could you clarify that? Was that your interpretation of Carter in relation to advance consent? And then I have a question about, well, just answer that if you would, please. Thank you.
Yeah, that's simply not true. That is not what the Supreme Court of Canada said. The Supreme Court of Canada said that a prohibition is void if it prohibits somebody from accessing MAID who clearly consents. That is not the same thing as saying that MAID is permitted only when someone clearly consents. They answered the question they were asked, which was about people clearly consent. And they said, if you prevent people here who can clearly consent, you're breaching the charter. That says nothing about what the requirements need to be. So I even heard that earlier today, actually, and I heard it from another witness. It's bizarre to me.
Thank you for that clarification. I think it's extremely important. My question is this. I know you have concerns about pre-diagnosis advance requests. 2 quick points. One, once you're diagnosed, people could challenge, I guess, your competence. But more importantly, wouldn't a history of detailing an advanced request and concerns about a prolonged life under intolerable suffering by that person's definition, wouldn't that be helpful in assessing whether the post-diagnosis request was valid?
Yeah, absolutely. I think the longer you have had conversations about what a person wants, the better situated you're going to be for understanding the request. But more importantly, the better the request is going to be. Because what we don't want is the kind of situation that Dr. Ferrier mentioned. You know, somebody says, I don't want to be a vegetable. We can't work with that. It needs to be very clear. We need to understand the values and the meanings that are behind the requests.
Which was Dr. McDonald's point too about education.
Absolutely, absolutely. And so yes, over time that is true. I would say partly why I'm all in on after serious diagnosis, and I may seem to be somewhat more lukewarm on pre, is because I'm juggling from a public policy perspective. I think it's absolutely defensible, and in fact we need to do it after diagnosis because of the reports that have been done, the public sentiment, the clinicians, all those. From a personal philosophical perspective, I would advance before. I think we can sort out those problems, but I'm trying to navigate bringing to you what I think the best public policy arguments are at the moment. And there is a real reliance on the work of those prior committees and expert panels.
Thank you, and thanks for the clarification as well.
Merci beaucoup. Senator Delphon.
Thank you. Senator Delphon, you have the floor. Thank you, Chair.
Professor Dr. Downey. We all agree that if we have advance requests, it should be in cases of irremediable condition, and that should be well defined. And what seems to be bugging some people is the concept of intolerable suffering. And you say when you lose capacity, sometimes you're not suffering of your new situation. So maybe we should say that it's an irremediable conditions, which is, according to the person doing the advance request, an unacceptable irremediable conditions. Would that be better than to refer to intolerable suffering?
I think you could certainly conceptually make that argument. I think people may express concern that the sands are shifting. And so that's why I've tended to stick with the language of saying it's for the person to decide what constitutes intolerable suffering. So again, I might say from a public policy perspective, I would advance the intolerable suffering. From a philosophical perspective, I would absolutely agree with you. It is, what are the conditions under which you are having control over what happens to you in the future when you no longer are capable? You think that life, you want that life to end because the conditions are unacceptable.
Because behind it will be the principle of autonomy and the right to dignity instead of the removing intolerable suffering, which some people are not. They are completely at stage 7, but they are not suffering. They are lost. They are no longer the person they were, but they are not necessarily suffering according to those that observe them.
Yeah, I mean, I think with the end stage, you can still say they're suffering according to their conception of suffering because it would be an existential suffering. I think the case that really, the situation that makes your case would probably be unconsciousness. Because when you're truly unconscious, it's probably harder to make the case that you are suffering. But you would say that those are conditions under which I consider continued existence to be unacceptable. And so I am requesting MAID.
Thank you.
Merci. Nous allons maintenant aller à...
Thank you. Now, Senator Martin.
Thank you. My colleague talking about intolerable suffering, I'm just wondering, my question is for Dr. Ferrier. My mother suffered from dementia and, you know, in fear when she was having to get surgery for her fractured hip, I just wanted her not to suffer and to end her misery. And it was from my own position of just making judgment, and yet she bounced back so quickly, and at every stage I just saw her real joie de vivre. So I'm just wondering, would you speak from your experience regarding dementia, people living with dementia and suffering?
Yes, thank you for that question. So I think that people with dementia suffer if they're treated badly. It depends. It's like everyone. If you're badly treated, you suffer. And if you are cared for, surrounded by affection, surrounded by everything that you need, then generally you don't. There are symptoms of dementia such as agitation and so on that we can generally manage. In some extreme cases, we cannot. You know, a lot of things have been said during this panel about not wanting to be that person with the dementia. And I think that there's a lot of stigma in there. And so people are saying my suffering now is to think of myself as being in that position of those people in the nursing homes. And I don't want to be that person. That makes me very, very uncomfortable. I don't see my patients suffer. I've seen lots and lots of patients with dementia. It's very rare. And sure, you go through a bad time. And sure, you know, hips we fix because it gets people walking again. We don't always send people to the emergency room from a nursing home. If they have a fever, we might treat them in the nursing home, even if they die sooner of whatever infection that they have, because the stress of going to the emergency room would be terrible for that person. It would make them more confused. They would maybe spend hours on a stretcher. There are many, many things that would cause suffering to a person with dementia, but we don't have to do all of those things. We do the things that we really think are in their best interest and that lead to their comfort. And we're not going to do triple bypass. We're not going to do many, many things that a person who has normal cognition could go through much more easily because they understand what's happening. So I think the concept of suffering is very subjective, and I'm very. It troubles me to hear people talk about my patients in many of the terms that have been used tonight about I don't want to be like that.
Mr. Co-Chair?
I assume you don't have, you had 30 seconds there, but thank you, Senator Martin. Thank you to all the panelists this evening for your expertise, for your testimony, for answering our questions. We very much appreciate it. Professor Downey, Dr. Ferrier, and Dr. McDonald. It's a late hour for some of you on the East Coast, and so we very much appreciate that you took the time to be with us this evening, and you will contribute very much so to our deliberations. So thank you. And with that, we'll suspend momentarily and get ready for the next panel. Thank you.
Thank you.
just to take a minute to say a few things. Before speaking, please wait until one of the co-chairs recognizes you by name. Secondly, a reminder that all comments should be addressed through the joint chairs. When speaking, please speak slowly and clearly. This is for the interpreters. Interpretation in this video conference will work like an in-person committee meeting. You have the choice at the bottom of your screen of either floor, English, or French. When you are not speaking, please keep your microphone on mute. With that, I would like to welcome our witnesses for panel 3. This evening, we have, as an individual, Dr. Romain Gallagher, clinical professor, palliative medicine at the University of British Columbia. We have Dr. Lillian Thorpe, professor, University of Saskatchewan. And we have, perhaps I should say this in French, le Dr. Laurent Boisvert.
Dr. Laurent Boisvert, who is a physician.
We will begin with the opening remarks of the 3 panelists. You will each have 5 minutes. Try to stay on those 5 minutes. And we will start with Dr. Gallagher, followed by Dr. Thorpe, and then Dr. Boisvert. So Dr. Gallagher, the floor is yours for 5 minutes.
Thank you to the Joint Committee for allowing me to speak. I'm a retired physician with over 25 years experience providing palliative care in all locations of care. I've been an attending physician and palliative care consultant to people with dementia, as well as physician director of long-term care and a physician leader in academic palliative care. I cared for my elderly neighbor who wanted to stay in her house where she lived alone despite her dementia. She had no children or spouse, so we were her family and I was her power of attorney for the last 4 years of her life. She died at 96, having lived in the same house since she was 8 years old. With respect to advance requests for MAID, despite the compelling evidence of wanting to be able to make some choice, medical and social science literature reminds us that people are poor at anticipating what life would be like with a life-changing illness or disability. People adapt to illness and disability and adjust their needs for a decent quality of life. Many medical conditions have long and unpredictable courses, and suicidality caused by these conditions can last protracted periods of time. In jurisdictions where advance requests are permitted, physicians have difficulty following advance directive for hastened death because they cannot reaffirm consent and they cannot establish current suffering. Family members have the same conflicts and find it a burden. I want to focus on the suffering of people with dementia. People with dementia can self-rate their quality of life, and we know that they consistently rate it higher than caregivers do. Cognitive abilities have little impact on their quality of life, but good relationships, social engagement, and spiritual and religious beliefs help maintain quality of life. We do know, though, that losing functional ability, pain, and depression can reduce quality of life. A 2018 study of the lived experience of over 600 individuals with dementia revealed the importance of their physical environment and the people they interact with. A positive environment allows people with dementia to continue to participate in life and includes caregivers who facilitate retaining control and a sense of purpose. Through adapted physical environments like dementia villages, people with dementia can continue to walk outside and express their emotional, relational, spiritual, and creative selves. Technology can also aid us in reminding one's identity and memories. The fear of losing capacity and losing control over their lives may not be realized because they are still recognized and treated as a person. Dr. Tom Kitwood was a researcher in maintaining personhood in dementia, and he concluded that personhood is a standing or status that is bestowed upon one human being by others. It implies recognition, respect, and trust. He described how our actions undermine a person with dementia's personhood. conversing with others as if the person with dementia was not present, infantilizing, disempowering by not letting someone walk unsupervised, treating people like objects, and taking away control of every decision. It is our society's behavior that contributes to the suffering of people with dementia and fuels the stigma supporting the idea that with dementia, a person dies inside a living body. Those with money can buy adapted environments with supportive carers. If we allow advance requests, those who can't afford adapted environments will have only an illusion of choice. They will choose between depersonalizing care or MAID. Providing a palliative approach to care that focuses on maintaining quality of life and providing care that meets preferences of people is essential. Yet a CAI study in 2017 showed only 120 people with dementia actually received palliative care. I wrote a brief to this committee that argues that those suffering without access to quality palliative care or receive it only after they've requested MAID is a medical error. The error is not in receiving MAID, as the person may meet all the requirements. The error of omission occurs in the months before when the pain, shortness of breath, anxiety, and feeling a burden to others began but was not recognized and addressed. This is an error because we know palliative care can help with this and improve quality of life, and every chronic disease organization recommends timely access to palliative care. I want one of you to ask me how the federal government could achieve greater access to palliative care.
Thank you, Doctor. We need you to wrap up.
Okay. Parliament has voted 3 times in favor of funding palliative care strategy. It's 2022 and it is yet to be implemented. Canadians will suffer with life-limiting illnesses whether they access MAID or die naturally. They are counting on all of you to ensure quality, timely palliative care and ensure it's provided to all Canadians. Thank you.
Thank you, Dr. Gallagher. We'll now go to Dr. Thorpe. Dr. Thorpe, you have 5 minutes.
Thank you very much. And thanks for the wonderful presentations I've heard so far. I'd like to say I'm a geriatric psychiatrist. I see people and work with people with dementia and very much agree with many of these comments about personhood and developing environments where people can live productive and quality lives, even in dementia. I think it is very clear that most people I know do want to have access to advanced requests for MAID. I also think this is going to be really challenging, and we're going to have to really think about those guidelines and how we're going to do this. And so first of all, people really do change. I see people in hospital with my consultation service. They made an advance directive years ago that is not what they want often anymore. They say that was then, this is now. People change, and people don't necessarily they don't necessarily understand what they adapt to over time, which is what Dr. Gallagher talked to. So many really do change, and they adapt to levels of stages in their lives, such as dementia, that they wouldn't have expected before. So these people are not necessarily the same people that asked for this. So I think what we do in real life is we look at balancing the current person with all of their needs, which is somebody with a dementing process needs a lot of help, with what they previously wanted. It's a balance, and that balance is often discussed within a mixed group of people that then really thinks about all the issues that we might have to think about in making a very complex decision. So practically speaking, I think some cases are going to be fairly straightforward to approve and an advanced request. If a person still has some ability to say what they want, and I have a number of patients, now I've mentioned I've seen close to 700 MAID assessments. I am a MAID assessor and provider. So many of my patients with dementia in early stages do still have some ability to say what they want. And some of these do talk about wanting to have access to MAID. And when they're in that early stage, even if they don't have fully informed consent, they may have assent. And those ones, I think, will be ones we can deal with. There are people in a chronic vegetative state at the end. They may not be suffering anymore, yet we will also find those reasonably doable for us as providers, that we can feel we can live with this. Now, the problem comes really in people who have this gradual loss of capacity and insight into the dementia. My patients often say, actually, I don't feel so bad anymore. I think I'm not even sure I have dementia anymore as they progress. And they may enjoy their environment. They no longer focus on developing dementia because they don't really know they have it anymore. So those will be very difficult for us to deal with, as would those who develop a lot of agitation and resistance. So it's hard to even get them to take their medications, let alone large amounts of oral medications for MAID or get an IV started for MAID. Those will be highly difficult and would be highly traumatic to both providers and family members and care providers. So I have a number of suggestions which I put in my written report, that I think that the straightforward situations, such as when a person is making some suggestion consistently that they do wish to die, that will happen sometimes, or if they're in a chronically vegetative state, and that the advance request is sufficiently detailed to support the situation, that could be approved by the usual trained objective MAID assessors. There are, however, going to be far more complex situations where there's no consistent communication from a person saying they wish to die, or there's a lot of conflict amongst family members whether the advance request was really going to be consistent in the current situation, in which case I think there needs to be a very different process with consultations with some of us, like a geriatric psychiatrist, such as I practice, a geriatrician, psychologists, and so on. I would like to see evidence of ongoing significant suffering and no evidence that the person is actually consistently enjoying life. If a person's consistently enjoying life and enjoying activities, I would feel very uncomfortable with that as a MAID provider. And I would like to see no resistance of any kind to the MAID assessment or provision. People trying not to have the IV started or taking oral medications. I don't think any of us would feel comfortable then. And I think what this means is we need interactive meetings between the care team, family members, health proxies, MAID assessors. We work through this, maybe ethics there, maybe a number of people, but not just one person or two people making these complex decisions, maybe social work to help with counseling and family members who are very, very distressed. And I'll just tell you, we do have waiver final consent. I've had two daughters sobbing in having to talking about this waiver because they say they would feel like they would be killing their father. And those patients who have had conflictual relationships with family members are going to be the most distressed with this. So I think there needs to also be an appropriately constituted end-of-life committee that could look at these complex cases, and these are going to be really hard, and have a lot of discussion about this. So that's what I'm going to say. I'm sorry, it's very practical. I'm not going to be able to tell you a lot of all the details in the other countries. I'm just talking to you about myself as a geriatric psychiatrist and someone who sees patients day in, day out. And I just wanted to talk about those practical aspects. So thank you for having me.
Thank you, Dr. Thorpe. Nous allons maintenant procéder au Dr.
We will now go to Dr. Laurent Boisvert. Dr. Boisvert, you have 5 minutes. First of all, I'd like to thank the Special Joint Committee for inviting me to testify as part of its work to address the issue of advanced directives in the context of MAID. I am a family medicine specialist and have practiced for almost 35 years in emergency medicine and as a clinical professor. I've been concerned for several years with end-of-life care and more specifically with euthanasia. I made sure that medical assistance in dying would be available as soon as it came into effect in Quebec in 2015. I'd like to present 2 cases of patients with dementia in order to address the issue of advance requests. Mr. Yves Manette, and I can name him since he has been extensively covered in the media. Mr. Manette suffered from frontotemporal degeneration, which caused a variety of atypical symptoms. He lost control of his limbs. He could do incongruous things like taking a shower with his clothes on or going outside in his undershirt. His illness was advanced to a point where he no longer recognized himself. He asked multiple times for MAID, but the legislative context was such that he was not eligible. But this was making his life increasingly difficult. I met with him in April 2021 following a press article. When I met with him, I confirmed that his request was admissible, but since his death was not reasonably foreseeable, he had to wait 90 days. He accepted on the spot, happy to know that he wouldn't have to endure his existence much longer. He offered to donate his organs as he was in excellent shape. He never went back on his decision. In spite of his dementia, he remained capable and able to repeat his request clearly, which is not the case for all people with dementia, as we shall see in the next case. He passed away calmly, surrounded by friends and family, in a uniform lent by the Longueuil police, with boxing gloves on. And then Miss C, an 84-year-old patient who had been active, cheerful all her life. I met with her in 2021 to evaluate her request for MAID. The previous fall, during a family meeting, the children noticed that their mother was behaving strangely. She seemed a bit uninhibited. She also made occasional incoherent remarks, but it was a subtle thing. You would have had to know her to notice the incoherence. Following the examinations, the diagnosis of Alzheimer's was made, which surprised no one. When I met her, she understood her illness and explained why she did not want to extend her life unnecessarily when she could no longer be able to be independent. She didn't want to be a burden on her spouse or family. She understood what she was asking for and about its irremediable consequences. I informed her of the legislation and its constraints. I told her she would have to be followed very carefully. But the legislative context meant that we had to steal time from this woman and her loved ones. And this because she wasn't able to clearly express her wish during a certain time. Right now, she can no longer clearly express what she wants. She's confused, disoriented, and even incoherent. She's no longer capable. So she can't have recourse to MAID, and she's living in a way she did not want to live and in which she did not want her loved ones to live. So her loved ones will have someone they no longer know. They'll be dealing with an individual who may become unpredictable and aggressive, someone who has no interaction with the outside world. Advance requests. I agree with the fact that the law must allow the people with dementia to make an advance request. This would be a binding request, and there would be certain criteria, for example, clinical assessment that would trigger the procedure. You can't always. It's very difficult to decide who suffering or irreversible decline. I think a third party or third parties who would have to identify things in order to trigger the procedure in consultation with others. In the absence of family who might make this request, others would have to do it. The public curator in Quebec would probably have to play this role. I therefore thank you for your attention and wish you the greatest foresight and the necessary courage to move forward on this important issue. Thank you, Dr. Boisvert. We'll now move to the round of questions, and I will transfer control to my co-chair.
We'll go with the first round of questions from the House. Mr. Cooper, you have 5 minutes for your questions.
Yeah, thank you very much, Madam Co-Chair, and thank you to the witnesses. I'm going to be addressing my questions to Dr. Gallagher. Dr. Gallagher, in the last panel, Dr. Downey said that it would be illogical not to extend advance requests, and there are advance requests in the context of MAID in some limited circumstances, but to expand upon that, having regard for the fact that advanced decisions, including with respect to the withdrawal of life-sustaining treatment and other medical interventions are already available for patients to decide upon, and that with respect to the issue of safeguards, that safeguards that are in place for those advanced decisions could quite easily be adopted in the case of advanced requests for MAID. What are your comments to that?
Your microphone, Dr. Gallagher.
Thank you very much for the question. I did hear that comment, and I think there's a huge challenge because of the things that I said in my commentary that we know from, it's got to be about 30 or 40 years of research into effective forecasting that people do not tend to think things will always be worse in the future than they actually are. We also know that people adapt as well. And I think when it's very different from saying, I'm nearing the end of my life. I want assisted dying over the next few days, but if I should lose my capability, these are my wishes. The average lifespan of people after diagnosis of dementia is up to 5 years. And I find the idea that Dr. Downey mentioned about, if I don't recognize my family for 2 weeks, then you can terminate my life. And I'm thinking, now, how are we going to compel doctors to do this, right? I mean, this is going to be an extremely challenging thing to work out. People change doctors, they change locations, they change provinces. This is going to just be a nightmare, and I don't see how arranging a deal with one provider will last one through a long trajectory of an illness.
Well, Dr. Downey seemed to present it as though it would be very easy, that you would sit down and that you would work out this arrangement and you would discuss intolerable suffering. Of course, you're not experiencing that intolerable suffering, so it's just you're discussing it beforehand without living it. But somehow, according to Dr. Downey, that will result in a written request that will be able to speak for that patient and will not need the guidance of a third party because it could all objectively be assessed to determine whether or not the patient's wishes could be carried out. What are your thoughts on that?
Well, I think it would be incredibly challenging, and my work in long-term care has really taught me that usually people who arrive in long-term care will often last longer than you think, and it'll be more complicated than you think. And I think trying to make it out as a simple exchange between two people is bound to be complicated. And I think Dr. Ferrier in the previous session mentioned that about how complicated it gets with blended families, with people who have different ideas about wills and so on. It really does complicate things, and particularly where people have a previous strained relationship with with the patient.
There's about
thank you.
20 seconds.
I'm out of time. Okay.
There's about 20 seconds.
Okay. Well, I guess for all is there anything else you'd like to add in those 20 seconds, Dr. Gallagher?
Oh, well, I was hoping someone would ask me, but I can't do it in 20 seconds. And it's about how we could improve palliative care, because through accreditation, we could expand standards and screening for distress throughout all chronic diseases. And that is the way to enforce this, is through an accreditation. It would make a huge difference.
Thank you, Dr. Gallagher. Next, we have Mr. Maloney for 5 minutes.
Thank you, Madam Co-Chair, and thank you to all of our witnesses. This is challenging discussion, but it's one we must grapple with. So, Dr. Gallagher, I'm going to ask you one question. You started by saying that literature shows people are poor at anticipating change. Is there any scenario in which you think it would be appropriate for advance requests for medical assistance in dying, or do you rule it out entirely?
Well, you know, I tend not to base things on one case or the rare case or things like that. I think we have to make policy that will manage for most Canadians. And I often think, as we do in medical situations, where we talk about benefits and risks. And I think the benefits of, it's very compelling to say, gosh, if, you know, take me out of here. And, you know, I used to think like that when I hadn't spent much time in long-term care. I'd just pop in and I think, oh my God, this looks terrible.
Okay.
But when I worked there, I found it was very different. So
Thank you, doctors. I don't mean to interrupt. I don't have much time. So the answer is no. And is part of that reason because it's your view that once people enter a certain state, they're not able to provide their consent?
It's partially because of that, but it's also because they may not have the same degree of suffering, and they, you know, may have adapted to things, and it's extremely hard for someone else to judge, particularly when people are unable to communicate as well as they used to.
Okay, well, I'm going to ask this question to the other two panelists. In terms of consent, I mean, informed consent is a legal concept. It is designed to protect patients. But what we're talking about is real-life personal decisions that people have to make about their own health. So my question is, would you not say that people can make an informed decision to request MAID, knowing that when the time that it is administered, they don't have the capacity to change their mind?
Dr. Thorpe, first. Your microphone, please.
I think no. I think people, the longer the time is between a request and the actual event, the harder it is to anticipate how one feels and how one interacts with the world. I think it would really, it's possible to have an informed consent when it's a very short period of time, you know, but the longer it gets, the more you change. And I think it will be very hard to have informed consent. I think this will become a collaborative decision-making. I don't think it's so simple as just taking what somebody describes they might have wanted, exactly what their suffering would be, and then have everybody be able to act on it. I think it'd be really complicated.
Okay, Dr. Boisvert, that's a good segue over to you, because that patient you described who has Alzheimer's, wouldn't she have been able to provide you with informed consent and not be in this situation she is now in the scenario I've just put forward?
Dr. Boisvert?
Quand moi j'ai rencontré la malade, elle était...
When I met with the patient, she was quite capable of defining what she wanted to live with and what she did not want to live with. She was able to do that very specifically, and if she'd been able to make an advance request with a third party identified as a proxy or power of attorney, she could have specified the criteria. She could have said that when these criteria were met, then she wanted to have access to MAID, and her attending team could have proceeded.
That scenario, then, who would make the decision with respect to whether or not the criteria had been met?
Dr. Boisvert?
Dr. Boisvert.
Yes, about 30 seconds.
Le tiers fait partie de la...
A third party, this would be part of the process. The third party would know the criteria that would trigger the procedure, but it would be her healthcare providers and two physicians would have to establish that the criteria had been met, that the request was eligible and admissible.
Next, we'll have Monsieur Thériault for 5 minutes.
Dr. Boisvert, si je comprends.
Dr. Boisvert, if I've understood, and thank you very much for talking about these two cases, I think that always really makes it more tangible and illustrates what this is all about. So, free and informed consent in your practice, well, some say it's almost impossible to be informed when you make a decision 7 years or several years before the fact. What do you think of this? Well, I think that someone who is competent and makes this decision, that person must specify the criteria that would specify when this should happen. It would be that person who had decided on the whole approach freely and informed. Does that need a diagnosis? Well, I agree with Dr. Downey. I think when we deal with advance requests, there can be a diagnosis of dementia or neurodegenerative disease, which will have a certain outcome. And these requests, are they simply for degenerative neurocognitive disorders? Well, advance requests are made because the patient knows that he or she are going to lose their capacity and that they will be dealing with degenerative neurocognitive issues. It could also be that if they have a diagnosis of dementia, but it could also be something like Parkinson's, which is a neurological disease which has cognitive issues. There are also cases of multiple sclerosis, but usually there is no neurodegenerative aspect. What about questions of, what about when there's a stroke or that kind of thing, which creates a case of incapacity? Can this be dealt with through advance directives? Well, it's not possible for someone who's well to say, I want to have access to MAID if I have a stroke. Well, no, but at the present time, you can have advance requests. I could say, if I have a stroke and then I have a heart attack, don't revive me. That I could say that. That's just an example. Does this regime cover this kind of thing? Does it not already exist? Yes, advance directives in Quebec would cover this kind of thing, but this is an entirely different mechanism. This would be a directive where they say you will not do this. But in an advance request, what you're saying, you're asking for something positive. You're saying you will perform a MAID. Are there cases where your patients are in, for example, final stages of Alzheimer's? Do you think that palliative care in these cases constitutes aggressive care or heroic measures? Well, if the patient had made an advance request for MAID, then we wouldn't perform these heroic measures. The way you present this example, there are certain measures which aren't necessarily safeguards, but when you make an advance request, that is a binding request, and if you go against it, that's more than heroic measures. And that's a fundamental thing. Yes, fundamental. There are people who say that their patients, once they are informed won't opt for this kind of solution. What is your opinion? Because very often we hear about people, we've heard this from witnesses, who say that when their patients are properly informed, these patients do not opt for advance requests. Thank you.
But next we'll have Mr. McGregor for 5 minutes.
Je faisais allusion au paternalisme médical.
I was alluding to medical paternalism.
Thank you, Madam Co-Chair. So we've heard from Dr. Gallagher in her opening statement, that people are poor at anticipating what future medical conditions are like. Many witnesses have talked about the difficulty in determining consent. Dr. Thorpe, our committee hasn't yet had your submission distributed to us, but we will look forward to reading that in detail. So I appreciate you submitting that to our committee. Just in your opening remarks, when you urged our committee to really think very clearly about the guidelines that need to be set up because of the fact that people change and in some cases adapt to their new medical realities. I guess, from a practical point of view, in terms of, what our committee may make recommendations on, checking in, like if we permit advance requests for medical assistance in dying, for you as a practitioner, like how often would you want to see someone, I guess, be legislatively required to revisit their advance requests so that we can be sure that, is it every year, every couple of years, every 3 years? I don't know. Like, is that something we as a committee need to be really checking in on so that people are, being required to look at their advance requests to be sure that this is something that they still want as time goes forward?
So thanks. That's a good question. I think it depends on what's wrong with a person. If we go with Jocelyn's idea that we only have these for someone who's had a diagnosis, if somebody's had a diagnosis of dementia, they probably need to redo this every year because they will have decline every year, and I think it should be done. Now, if one didn't have the requirement for having a diagnosis, which I actually wouldn't rule out. I think that some people have a family history of very severe dementia, and they might want to indicate what they would wish at, say, a chronic vegetative state. That might be a very different thing, and that might be a 5-year thing. But once one has a chronically degenerative condition very, very frequently, even quicker if you had something like Creutzfeldt-Jakob disease, which is very fast, progressive. So I think there are a lot of these very context-specific things that we'd have to think very hard about. I don't think it's undoable. And I'm not saying we shouldn't have advance requests. I'm just saying we have to really think about this and think about the practicalities of those of us who are going to end up seeing someone walking around, not knowing their family members, but still enjoying life. How are we going to do this? Are we going to hold them down? I can't see any of us doing this.
And I guess would you like seeing would you appreciate as a physician, would you want a standardized type of request, i.e., like this is the bare minimum amount of detail that is required on a form, and it also has to be accompanied by a personal note to better fill in the blanks that form may present. Can you elaborate a little bit more on that specific
Absolutely.
part? Yeah.
Absolutely. You know what Jocelyn talked about, that's going to be really important to have down exactly what that person's wishes are at that time. It's also important to have that person meet with an informed someone, a physician or a nurse who knows what dementia looks like, and really have that documented that person did have actually full understanding of what they were talking about at the time, being that as it may, that they may not fully understand what happens in 20 years, but at least we have some idea that they had a discussion with someone to think through all the issues. And I think people very frequently sign things they don't understand. Very common.
And on that concept of fully knowing what dementia looks like, and we've often heard during this committee that, there is a stigma that many people have about, like, oh my goodness, if I were to get a diagnosis of getting Alzheimer's, my life would essentially be over. and they look at the state of long-term care in Canada, and there's a very real fear there. So like in your conversations, what have those been like for you, like on a practical sense, and dealing with those very real questions and fears that people have?
So about 30
Yeah, I
seconds.
mean, I think we talk about dementia always being terrible, but it's not always. We have people sitting there in our good nursing homes that are singing, that are dancing along. They can't recognize their families. They're still having some quality of life, not what they anticipated, but they're still having quality of life. So that's the good ones. And absolutely, we need to improve palliative care and long-term care facilities. Absolutely, more person-centered care. Absolutely.
Thank you.
Thank you, and I'll turn this back to our co-chair for the questions from the senators.
Thank you, Senator Martin. And with that, we'll begin with Senator Kutcher. These are 3-minute rounds. Senator?
Thank you very much, Chair. I'm going to share with you a case that I know, and I'd like to hear from Dr. Boisvert and Dr. Thorpe about this. Here's a person with stage 7 dementia. They are unable to self-toilet. They smear their feces on the wall or eat them. They do not recognize their family. They fall unless they're tied into a chair. They can't eat solids because of fear of choking. But they get very good care every time they're dirtied or soiled. They get cleaned up. They get dressed up. They spend their whole day sitting in front of a television set, laughing and singing, clapping at TV shows, and moving their body in time to the music. Is the person suffering? How do you know if the person is suffering? If they had given you an advanced request saying, if I'm in this condition, I would like to have MAID, would that assist you in that decision making?
Dr. Thorpe?
So, Dr. Thorpe, do you want to start with that?
It would certainly help me to know what their thoughts were to start with. It would help me. But I also don't think that person would be able to necessarily predict whether they were suffering or not, because they're not there. That person does change. It's a person whose whole personal, emotional, physical experience changes. It's a terrible state of care state to be in. I mean, I think at that point, what do you do? It's going to be, the practicalities are going to be really difficult. Now, when somebody's this far gone, using sort of supportive end-of-life comfort care measures might be much easier to institute than actively getting medications into that person who is often, as I said before, often not even taking their drugs in anymore. They're not even eating much anymore. So I still think this is going to be a difficult situation. And there will be some situations that I've had patients with dementia have MAID, and there will be situations that will be doable, but many will be very difficult like this for everyone involved, family members, caregivers, and the providers.
Dr. Boisvert?
Dr. Boisvert? Would you like to comment, Dr. Boisvert? Yes, certainly. If the patient has made an advance request for MAID in order not to find him or herself in the situation you described, this is someone who will have defined the conditions, will have defined certain conditions, and if he has come to that point, then you would have to act according to as well as defined in his advance request. And no one could say that because his body is moving and he's listening to music. I think there is dementia with various kinds of, which is dementia which is expressed in different ways. And if someone is capable when they make the request in an informed manner, that person does not want to end up in the situation you described. Thank you, Doctor. Now, Senator Meji for 3 minutes. Thank you, Chair, and thank you to the witnesses. And my first question is for Dr. Boisvert. I'd like you to finish your answer to Mr. Thériault's question about refusing MAID to someone who had asked for it. And after that, I have this question. If the advance request is authorized, what obstacles do you see that might complicate the implementation and performance of MAID? Well, to the first question, which is the refusal, I will repeat. I think you would be acting counter to your ethical code. Someone will have asked for something, will have defined the criteria, and there are people who don't respect their ethical code when it comes to MAID. But I can't really say anything else. That I think that in the extreme, this would even run counter to the legislation and to the criminal code with respect to MAID. And now the second part of the question, the obstacles to the provision of MAID. Well, as is the case now, not all providers of MAID deal with all patients, and it's not wouldn't be any doctor or any nurse that would provide MAID on after an advance request. Because in the future, someone who has dementia is no longer the same person. The neurons are different. It's a completely different person, and dementia can be expressed differently. You could have someone who's aggressive, and as Senator Kutcher said, you could have someone who's moving with music, but this person will have defined the criteria for triggering MAID. So I think that these things can be done. You can provide MAID perfectly correctly. You have 10 seconds, but I think we'll move forward. Thank you.
Senator Wallen, it's over to you for 3 minutes.
Thank you very much. My questions, and I have two of them, are to Dr. Thorpe. We come from the same part of the world, Saskatchewan, and I want to ask about the rural-urban issue and access. Presuming that the pandemic has given everybody some experience with this, are you now comfortable doing assessments on Zoom or some other kind of technology, and does that actually create more access because people don't have to travel and you can do it more often?
So thanks, good question. Saskatchewan actually has a centralized MAID program. We have really good access throughout the province. We have people in most areas of the province, and there is now funding for the assessors and providers to go out, and their time is reimbursed. Some of the assessments are done virtually. We're all better at that now, but we like to have at least one of the assessments being in person, and we've generally able to have really quick response. We probably have one of the quickest responses across the country within a week, usually, often much quicker. But certainly virtual we've learned, and the second assessment sometimes easier to do in a virtual, and I have done quite a few of those as I'd see most of the more complex cases, and yes, so there's been some improvement with this, but I prefer to see them myself.
Thank you. My second question, and we've heard statements about this over the course of our hearings. Do you, as a long-time MAID assessor, do you know of any cases of forced MAID where a practitioner or a family member compelled someone clearly against their will to subject themselves to MAID?
Absolutely not. What I see much more often is that family members dissuade their families from having MAID. That is much, much more common. I've never seen it where anybody has pushed someone into it. You need two assessors, and you would absolutely be aware of that pressure with two separate assessments.
So the safeguards are in place?
I think so.
Yeah. Thank you very much.
Thanks.
Thank you. Sénateur Dalphon, à vous la parole.
Senator Dalphon, you have the floor. Thank you, Chair. Dr. Boisvert, my question is for you. In your experience, have you seen patients who have decided since the amendment to the legislation, patients who have asked for MAID and who have chosen a date, a closer date, because they're afraid of losing their capacity to decide? Well, yes, I have been providing MAID to certain patients who had dementia, who maintained their decision up to the last minute that they could. But they still wanted to spend some more time with their loved ones, but they had specified criteria. For example, when I can no longer take care of myself or recognize my loved ones, but that could take months, in some cases, years before that happened. And I believe that there were people who were fighting for these advance requests. So yes, there have been patients who decided on MAID too quickly because they couldn't make an advance request. So if you don't change the system, this would be depriving people of the choice to live for extra months or years because you're making them to choose MAID right now. Exactly. Thank you, Doctor.
See, now we'll go to Senator Martin. Senator Martin, you have 3 minutes.
Yes, thank you, Chair. My question is to Dr. Gallagher. Dr. Gallagher, based on your experience and knowledge, what do you see are the major risks of advanced care planning that includes MAID? What should we be aware of?
Well, I think you should be aware of the extreme difficulties in actually deciding when and how to do this. And I think there's really little evidence that shows that doing it this way or that way or defining some kind of arrangement between two people will sort out the problems. Life is difficult and things don't always work out that way, the way that one plans. And I think knowing, and as Dr. Thorpe has very ably pointed out, that life is complicated and things are challenging and it's not easy to do this. So I think there are lots of risks and the benefits are hard to measure, so I do not believe it's in the best interest to actually enact this kind of legislation. I think it's very problematic.
In the time that I have remaining, would you like to talk a little bit more about what the federal government should do regarding palliative care?
Oh, thank you. Really, what we want to do is have a system where we know all the provinces have to rely on accreditation of their organization, and therefore you can put in place standards and measures of quality of palliative care. You can also enact symptom screening and distress screening in all chronic disease clinics, because I believe that doctors have great intentions, but they often aren't focused on symptoms. They're focused on disease indices and testing and so on. And we need to hear from people. People will often rate very differently on a survey than they will admit to their family doctor. We need to pick up suffering early, and we need to have a system in place that ensures that we are detecting this and addressing it early before people are suffering to the point where they actually say, my life is intolerable the way it is right now. So it's my hope that, knowing that this is within the control of the federal government, that you will actually, in your role as reviewing the state of palliative care, that you will take this incredible step to enforce a change in our system which will benefit everybody, no matter whether they have MAID or whether they have a natural death. I think it's very important, and I thank you.
Thank you very much. I'd like to thank Dr. Gallagher, Dr. Thorpe, et le Dr. Laurent Boisvert. Merci pour.
And Dr. Laurent Boisvert, thank you for your testimony. Thank you for having answered our questions on a very important and very complex question. It's highly appreciated. And thank you for having made yourself available so late, certainly for those who are in the east of the country.
We very much appreciate you being with us this evening. With that, to the committee members, just a reminder that our next meeting is 1 week from today. It will be a 3-hour meeting, and as agreed upon at the beginning, we will reserve the third hour for in-camera committee business. Just before we adjourn, there has been a suggestion that we extend the period for people to provide briefs, given the fact that our final report has been extended into October. So I'd like to see a show of hands if people would support allowing briefs to be presented up until the 30th of May. Does anybody have a problem with that? Now, I can't see everybody in the room, but I'm looking at
thumbs up.
Lots
Everyone.
of thumbs up.
Yes.
Okay, well, that sounds very good. So we will notify people that they can provide briefs. Length is still 1,000 words up until the 30th of May. Thank you very much. This meeting is now adjourned.